Hi, I'm Waco criminal defense attorney Walter Reeves, and today I want to talk about one of the questions that we frequently get from clients and family members about sentences they believe people receive for cases similar to theirs or worse than theirs. The conversation is usually something along the lines of, I've seen cases where someone committed murder and got probation, or maybe people do something way worse than I did and are getting lower sentences. My usual response is that you can't compare sentences. And also that for everyone who got off with a light sentence, there are examples of the opposite. For example, someone with a minor theft offense who gets life in prison. I realize that's not a very satisfying answer. So I'm going to try to explain why people get different sentences for what may seem like the same offense. The first thing you have to recognize in Texas is that there are huge ranges in the potential sentences available. For example, in a third-degree felony, the range can be anywhere from 2 years up to 10 years. For a second-degree felony, it can be anywhere from 2 years up to 20 years. And for a first-degree felony, the range is even more. It can be as little as 5 years all the way up to 99 years or even life. So how does a prosecutor decide what to offer in a case? The first thing they consider is the actual facts of the case. For example, murder can be committed in a number of different ways. One extreme is an elderly person whose spouse is terminally ill and begs them to put them out of their misery. On the other extreme is someone who just gets upset at someone, seeks them out, and kills them. Both are intentional offenses and intentionally taking the life of someone, but they are two entirely different situations. The second thing that is considered is the background and history of the defendant. You would probably guess that someone who has several prior convictions is going to be treated differently from someone who's never been in trouble. And the final thing that's looked at is not as clear-cut, but that's the strengths of the state's case. That's not always a factor, but it can be a consideration when the evidence is strong, or also when the evidence may be weak in a case. We had a robbery case where the offense was on video, the defendant confessed after he was caught, and there was DNA left on the scene which matched the defendant. There's not any way a prosecutor is going to lose a case like that, so they don't really have much incentive to negotiate. The opposite is a case that involves some assumptions. For example, in the same robbery case, the only evidence might be that the defendant was found in possession of property taken during the robbery. If that evidence was found several weeks later, there's a chance they got it from someone else, and so they may not have actually committed the robbery. Where the evidence is weak, the state may make an offer below what they normally would in order to avoid the chance of going to trial and not getting a conviction. And there's another reason which is not as easily understood or explained, and that is that different prosecutors view cases differently. And while that may not be entirely fair, it's just a fact of life. An experienced criminal defense attorney knows how to take all of these factors and use them for your benefit. If you liked this video and found it helpful, please share it with your friends and family. And if you or a loved one need help with a criminal matter, please give us a call.